Good morning, everybody. I think we're going to get started whilst people are filtering in. So hello to everybody and a very warm welcome to our seminar, our webinar on the patent box. I'm Matt Greenwood from Briars and with my fellow presenters today, we're going to talk to you about the patent box. This tax incentive, which was introduced in April 2013 to encourage innovation in the UK. And it allows eligible companies to pay a lower rate of corporation tax. That's the headline. In terms of the statistics, recent statistics on the uptake of patent box, the last full tax year, there were only 1,500, just over 1,500 companies that took advantage of the system, and that strikes all of us who are presenting today as rather low. It's a pretty generous regime, and there may be a number of reasons why that's the case, but certainly one of which is that I think a lot of companies have found it a little bit intimidating, and it requires quite a bit of advice. And as I say, understanding the patent box is really a multidisciplinary thing, a multidisciplinary approach. Briars, Oldmill and Mitchell Moores have worked together for many years, and this is one area where certainly there's a lot of crossover. There's no one person with all the answers. So for the next 45, 50 minutes, we're going to share around the presenters and give you a flavour for the different things you need to be thinking about. A couple of housekeeping issues first before I hand over. That is, first of all, that we're recording this webinar. I hope everybody's okay with that. And the second thing is that if you've got any questions, if you can, very welcome to post in the Q&A section of Teams, and we will do our best to answer as many as we can at the end, or obviously follow up on anything else that we can't. So please feel free to post anything that you want as we go along. So our three speakers today, I'm very pleased to introduce. First of all, we'll be having a presentation from Marketa, who's a tax advisor from Old Mill. Next up will be Catherine Lakota from Briars, who is a patent attorney. And then last but by no means least, Justin Barrow, who is a commercial IP lawyer from Mitchell Moores. So without further ado, I'm very pleased to be able to hand over to Marketa.
Hello, give me a second while I load my slides. So I will start by just introducing the patent box and the core principles. So as Matt mentioned, patent box was introduced in 2013. It was introduced to complement R&D tax relief, which was already in place then. It is designed to encourage companies to develop and commercialize technology in UK, and also to retain the resultant IP assets in the UK. So what we get is a reduction of the corporation tax rate. It's a reduction down to 10%. So considering that the headline corporation tax rate at the moment is 25%, we're looking at up to 15% tax saving on the qualifying profits. So the patent box is a corporation tax relief, so only companies can benefit, companies who are subject to UK corporation tax. Companies who hold qualifying IP rights, who've undertaken some development activities associated with that IP rights, and also who make profit from exploiting of those IP rights. So the first step to access patent box relief is to elect into the patent box regime. You can do that within 2 years from the end of the accounting period where you want to use your patent box for the first time. Once you elected in, you stay elected in. You can revoke your election, but if you do so, you can't re-enter for 5 years. Now, when to elect in the patent box regime is a bit of planning point. So there are too late, too early scenarios. So, for example, too late scenario would be where we have a pending patent. So you can benefit from patent box on pending patent, but you can't make a claim until that patent is granted. So how it works is that once the patent is granted, you can go back up to 6 years and make a retrospective claim. However, to be able to do so, the election must have had been in place throughout that pending period. So in a nutshell, if you have a pending patent and you have a profit, definitely that's the point where you want to consider electing into the patent box regime. Now, too early scenario would include where we have a profitable company, but the patent box calculation return IP loss. And if you elect it in patent box, you can't offset IP loss against your other profits. So actually that could put you in a tax disadvantage rather than advantage. So the obvious condition to qualify is to hold qualifying IP. When we talk about qualifying IP, we usually mean patents. Catherine will cover patents in great detail in her session next. There are other qualifying IP rights which fall under patent box, but they all quite specific niche areas. So the patent needs to be held outright, or the IP rights need to be held outright or through exclusive license. And Justin will cover the exclusive licenses in his session later. So that takes me to the last point on this slide, and that's the qualifying development test. So the claimants are expected that they were involved either in creation of the invention itself or further development of that invention, for example, by finding an alternative use or application of the technology. So in that sense, the qualifying development activities can take place before or after the IP asset is created or acquired. What will not fall under qualifying development would be commercialization, so marketing, product rollout. Also, if the only way how the eventually, so if the 100% R&D is outsourced, then they would not meet the qualifying development test either. So this came in 2013 in the original version of patent box. The patent box regime was then updated in 2016 following some complaints from Europe that it's too generous. And at that point we have a second point of interaction between patent box and R&D introduced, and that's the R&D fraction, which is now part of the patent box calculation, and I'll talk about that one a bit later. So to put this in the context of the innovation cycle, so what we have is we have this idea, we're going to develop the idea, we do lots of R&D, we develop the technology, ratify the technology, develop the product, and the company can claim R&D tax relief here. The R&D tax relief is expense-based, so the company doesn't have to be profitable, it doesn't have to be income generating to benefit from R&D tax relief. So at some point during the R&D process, we might put the patent application in. And then if R&D is successful, we go to the commercialization stage. If the product rollout is successful, we start receiving sales or royalties. And at that point, the patent box comes into the picture. Now, ideally, this from patent box point of view, ideally, this all takes place in one entity. And if it doesn't, then we can have some complications or problems. So common scenario would be where the inventors, so the idea and the initial R&D is done by the inventors in their personal capacity. So that would have to be remedied, and there would have to be some restructuring done to put everything in correct place. That's okay if it's done early, but if it's done in later stages when the IP asset accumulates value, then that can come at tax cost. So the standalone company obviously is not the only commercial scenario. So we have groups, for example. Groups have some special rules within the patent box regime. For example, when I talked about the qualifying development test, there are some modifications for groups, and they mean that, for example, if we have a group which has an IP holding company and an R&D company, they can both qualify for patent box. They can both be qualifying companies for patent box relief. But this has to also be considered in the context of the 2016 amendment and the introduction of the R&D fraction, because that does not mirror the spirit of these group relaxations completely. So if we have a group with IP holding company and R&D company, the IP holding company is going to likely fail the patent box claim on the back of the R&D fraction principle. It's quite common to have a cooperative R&D, and there are some structures available to accommodate that, which work with patent box, for example, corporate partnerships or cost-sharing arrangements, and Justin will talk about those later. I think the key points here are that plan early. Ideally, you will be in a correct structure from the start. If you're not, then put yourself in the correct structure as soon as you can. If you're looking at restructuring and there is some prospect that you will be claiming patent box in the future, just consider it carefully, make sure that whatever you do does not put you outside of the scope of the patent box. And this is the area where we would closely work with Justin and Mitchell Morse if there are any transactions or arrangements are being in place or restructuring. And then we would work together to make sure that whatever is being done works from legal, commercial, but also tax point of view. So the big part of making a claim is calculating your qualifying profit. I'll run through the calculation, patent box calculation briefly. So you start with identifying your IP-related income. Then you need to apportion your expenditure between your non-IP stream and your IP streams. So what you do is you basically creating these mini profit and loss accounts. Now, you want to be quite careful here. So if you're making your first claim, you have to come up with methodology how to allocate your expenditure between the income streams. And then you have to use the same methodology in future years. So you definitely want to make sure that whatever methodology you develop is going to be as good as it could be. The next step is a routine return deduction. So here we're deducting a proportion of profit which is deemed to relate to your normal commercial activities. So it's a profit you would make whether you have or don't have any IP. This is broadly calculated as 10% of your IP expenditure, excluding raw materials. Similarly, the next step then takes out the proportion of profit which relates to the company's marketing assets. And marketing assets would be trademarks or customer lists, for example. But it might be that there is no marketing asset deduction at all. So that would be in scenarios where you operate in a very niche area, you don't advertise to public, and you don't really spend much on advertising overall. So you might not need to make any deduction in this step. And finally, we apply the R&D fraction, and I'll talk about that a little bit more later. So said like that, it doesn't sound that complicated, but there are considerable complexities in every step. And I won't lie, the patent box is a complex tax relief, and the complexity of it probably historically put quite a lot of people off claiming. But it can be completely manageable, particularly in the SME space. And for example, we have some simplifications throughout the calculation available if we can make a small claims treatment elections. So I'll talk a little bit more about the R&D fraction. So that slide looks really quite scary, but I'll just shortcut it to as much as I can. So the R&D fraction looks at R&D spend and IP acquisition spend, and that's either outright acquisition or license fees. It looks at the cumulative spend, so it's not limited to how much was spent in the year of the claim. So we have a good expenditure and we have a bad expenditure for the R&D fraction. The good expenditure is your in-house R&D and any R&D subcontracted to unconnected parties. The bad expenditure is R&D subcontracted to connected parties, and that would include group companies, and also the acquisition of IP costs. If we only have a good expenditure, so if we have a IP which we only develop through in-house R&D, our R&D fraction is 1, that's 100% access to patent box relief. If we have some bad expenditure, then our R&D fraction might be less than 1, and in that case, our patent box benefit will be limited by that. So with R&D fraction comes a track and trace requirement, and that's obligation on current claimants and any prospective claimants to keep sufficient records of the expenditure which feeds into the R&D fraction to be able to calculate this R&D fraction accurately. So to put it in a context, if you are about to start an R&D project, and this R&D project will lead to a patent box claim in 2030, so in 7 years' time, you need to start recording that expenditure now, because you will need that records in a sufficient granularity in 2030 to make your claim. So the key message here is know what records to keep and keep them. And the last thing I want to talk about is so what income falls under patent box regime. So in the legislation, we have 5 heads of income, which cover sales, license fees, proceeds from IP sale, damages for infringements, and other compensation receipts. So that all makes sense. It's the worldwide income. So the territorial limitation of the IP right doesn't come to it. So if we have a product for which we only have a UK patent and no other patents, we still can include sales of that product in US in our patent box. It's not limited by that. So the most commonly we will see patent box claims for the head 1, for the sales, and that covers quite a wide range of scenarios. So our obvious one would be we have a patented product and we're selling patented product. But also we can claim for any products which incorporate a patented item or patented part. And that is quite generous, because so let's say that we have a car and the car has a patented gearbox in it. So the sale income from the sale of the entire car then falls under the patent box. You don't have to apportion it in any way. What you can do is include a patented part or patented item in your product if it doesn't have any function or commercial sense. So there are specific anti-avoidance provisions which would stop you doing that. We can also have a patent over process or plant and machinery, and then any income derived using that process or plant and machinery that also falls under the patent box. Although in those scenarios, the calculation gets a little bit more complicated because we have to use notional royalty calculation. It's possible, just more complicated. So there is clear opportunity here for companies to review what they have, the products they have, the processes they have. Is there anything we can patent? It can be a small part of the product. And if your primary reason to seek the patent is to access patent box relief rather than obtain the IP protection, you can go for a narrower scope patent, and it might be easier to obtain. And Catherine will talk about that in more detail next. This is the area where we would work closely with Bryce and the clients to kind of identify if there is something patentable in what they're doing. But also kind of estimating what the tax benefit from the patent box would be, so then we can compare the cost and the effort needed to obtain the patent with the potential tax saving which we can achieve through the patent box tax relief. And HMRC accepts that's fine. You can apply for patents to access patent box tax relief, and they say so. They make a statement to that end in their guidance. So it's not considered to be an abuse of that regime. I have 3 more slides, but I will not have time to go through those. I've lifted some examples from HMRC guidance, which are designed to illustrate the points about the qualifying income, which I just went through. So if you're interested, have a look. I've also run a brief hypothetical scenario calculation just to show you the difference between the corporation tax before and after the patent box claim is made. We'll share the slides, so if you want to have a look. If you have any questions, please do not hesitate to contact me. My contact details will be included in the slides. That's all from me. Thank you very much.
Marketa, thank you so much. That was wonderful. And now I am going to hand over to Catherine.
Thank you, Matt and Marketa. There we go. Opening up my slides here. There we go. Hello, everybody. So for the purpose of these next slides, I'm going to be assuming that the patent box claim is based on a patent. And Marketa has covered, from my perspective, only 4 key areas for patent box. The first 3 requirements listed here, that we need a patent that protects an eligible invention and it has been granted by an eligible patent office. It's very much within the domain of BRIAS. It's a core service for our patents team to be getting patents for people. It's the final one, the patent rights held by an eligible company. This is definitely where I'll be engaging with Marketa or Mill, Justin at Mitchell Moores, not advising on the patent box claim or company corporate structure. But these things could affect whose name we're pursuing patent protection in and when and where we start to pursue patent protection. So they are things that we need to know and liaise about. Now, patents are a type of intellectual property right. There are others listed towards the bottom of the slide here. It's a legal tool that can be used to prevent unauthorized use of an invention. It also can form a basis for a commercial agreement, such as licensing, which will be discussed further, and generally to increase attractiveness of a company for investment or sale. It is a type of registered intellectual property right, which means that we need to go through an application process to get your patent. Very important warning here. If you are considering getting patent protection on an invention, you must seek patent advice before publicly disclosing that invention, as prior public disclosure can destroy your opportunity to get patent protection. Patent application needs to meet various requirements. It should actually describe the invention that you want protection for, and it needs to include one or more claims. They're very important for a patent application. The claims define the invention in words. It is the claim wording that a patent examiner will use to assess whether a patent can be granted, and if a patent is granted, it's the claim wording that is used to determine the legal scope of that patent. A patent application and patents themselves typically include more than one claim, and there are different categories of claims. They roughly divide into product, process, and use. Now, when I talk about a product, I don't necessarily mean the whole product, and it can be a component of a product. Marquetta used the example of a vehicle and a gearbox. This is quite interesting. If the patented invention is, say, a component of an engine, then income from sales of engines incorporating that component can be used in a patent box claim. For processes, we also talk about them as methods. It's a way of doing something, or the way of making something, and uses are self-explanatory. Patent protected inventions that meet certain criteria, they need to be new and involve an inventive step. Now, the novelty and inventiveness of an invention is assessed using a patent filing date and by comparison with what was already known, and in the industry we call that prior art. To summarise very simply, an invention is novel, it's new if it differs from the prior art, and it's inventive if it's not obvious in view of the prior art. So we're usually looking for an invention to have a technical aspect that differentiates it from what's gone before, and in a way that's more than a mere design feature, something actually inventive. We also have requirements that the invention needs to be capable of industrial application. This is the provision that infamously excludes perpetual motion machines from being patented. And the invention also needs to not be excluded from protection. There are certain types of invention that are specified in at least the UK Patents Act and many others that just cannot be patented. They cover quite a wide variety of things, actually. A mere discovery in itself wouldn't be patentable, but an invention that utilises and works on based on that discovery can be patentable. And I've mentioned here computer programs. So in the UK Patents Act, at least, it says computer programs as such are not patentable, but there's plenty of computer implemented inventions that have a technical effect and do involve a computer program that are patentable and are patented. So for patent box, we need a patent for a product or a process. I've got an example claim set here. The claims are different categories. I've adapted it from the European Patent Office guidelines for examination. We have a claim 1. It is a process or a method claim of determining something in a device, comprising performing the steps A, B, and C. Now, this claim we call an independent or standalone or main claim, because all the features of the invention it's defining are actually defined within the wording of that claim. In contrast, our claim 2, which is again is a process claim, to what we call a dependent claim. To read the claim wording, it says the method of claim 1 further comprising performing step D. So here we have claim 2 including all of the features of claim 1 by reference, and a further limitation in the form of step D. So it's narrower in scope than claim 1. Now, in our set of claims, we have claim 4 here, which is a product. It's to a device having certain physical features, and also means adapted to execute the steps of the method of claim 1, claim 2, or claim 3. And claim 5 is a computer program product claim, comprising instructions to cause the device of claim 4 to execute the steps of the method of, say, claim 1. So these claims are related, but they very clearly defined into process or product claims. Patents are a territorial intellectual property right. We need to make a decision as to which country or countries you want to seek patent protection in. And a patent application can be a national or a regional type of application. For patent box, we need a patent granted by one of the patent offices listed here, including the UK Intellectual Property Office and the European Patent Office. Both of these patent offices are very common for UK-based companies to file that. And coming back to a very important point for patent box that Marquetta made, if we have in our example of a component of an engine that's been patented, if that's protected by a UK patent, then income from sales outside of the UK of engines incorporating that component can be used in a patent box claim. This slide here, so a patent application filed at an eligible patent office can be your first application filed for an invention, or it can be a subsequent application. Don't want to go in the ins and outs of different routes for filing for patent protection in a particular country. Some of you may be familiar with some of the language here, 12-month convention period or regional or national phase applications from an international application. The message here is that there are different routes to file for patent protection, and that your patent box patent may not have been from the first filed application. Okay. So patents can be owned by individuals or companies, human or legal persons, and they can be assigned in whole, or they can be licensed, and a license can be an exclusive or non-exclusive. Patent box, we require the patent rights to be held by a company that's liable to pay UK corporation tax and either owns the patent or is the exclusive licensee of the patent and meets other requirements, which is exactly where I'm going to Marketa for this. This is certainly a handover point, and certainly to Justin as well. I need to know whose name we're filing in. I need to know if we need to update the Patent Office details. But other than that, that's not my domain. So from my point of view, if I've got a patent file that I know is or is going to be subject of a patent box claim, what differences that make to me and my day-to-day handling of the case? You may want to get your patent grant sooner so you can get the patent box relief sooner. So that could be filing promptly, and by that it could be filing an application as soon as possible, but it could also mean filing supporting documents for that application well before the deadline that you have to do it. So that could be speeding ourselves up, or it could be accelerating stages of the application process by actually asking the Patent Office to speed up certain stages such as search, publication, examination and the grant procedures. The final 2 points on this slide: accepting a grant of a claim of a more limited scope and pursuing different claims in related patent applications are themselves related. So referring back to my example claim set, we have our claim 1, which is broader than our claim 2. The patent examiner was to, for example, say that claim 1, yeah, I agree it's novel, but it's not inventive, so you can't have your patent granted. But claim 2 is both novel and inventive, so would be allowable if you amend your patent application to claim 2. Then, depending on the timings, we could be having a conversation where say, okay, well, let's amend the existing application to accept grant of claim 2. We are checking that claim 2 covers exactly what you're doing. And then we could be filing what's known as a divisional application, which is essentially a duplicate of a filing, but with different claims. And we would be using the divisional application to continue pursuing grant of claim 1. So here we had the best of both worlds, putting the cost aside, of having a patent granted for a claim that's covering your product and that you can get on and get your patent box relief under, and also having a patent application pending for a broader claim. There are other opportunities within the patent filing system to have more than one related application with different claims, but don't have time to go into that today. And my final slide, other things that I may need to be kept informed about are developments to the invention. It's not uncommon for people to file patent applications for an invention and then to develop that invention, but we can't add any information into an existing patent application. So we would need to check whether an existing patent application or patent covers this latest version of the invention, and also whether the latest version in itself has a technical feature that makes it novel and inventive and could actually warrant its own patent application filing. Changes to patent right ownership and exclusive licensees, again, we could be involved with recording a transfer of rights at the Patent Office. Changes to the patent box rules. Have we got a patenting strategy with patent box claim in mind? But there's changes to the actual patent box rules that mean that we need to make corresponding changes to our patenting strategy. And very finally, keeping in touch with other people who's involved with the patent box claim. I've had many conversations with Marketa and Justin, and it certainly helps to know other people involved in a claim. So if I have any questions, I've already made their acquaintance, and it's very much easier to just pick up the phone and we all know what we're talking about, and we get enquiries dealt with much more swiftly, which is obviously better for our clients. And that's a very brief run through of my slides. So if you do have any questions, then I'll be available to answer them afterwards. Thank you.
Thank you, Catherine. That's very informative. And I think you can certainly see the interplay between the different advisors already. And now we're going to continue with that theme. And I'm pleased to be able to hand it over to Justin.
Good morning, everybody. Just checking I'm not on checking I'm not on mute. And thank you, Matt. So picking up from Marketa and Catherine, my part of the presentation will cover off where as commercial intellectual property lawyers, we bring our expertise to the table. So I've set out the 4 areas here. So we'll be looking to set, first of all, we need to understand the importance of identifying as early as possible in the process where ownership of the qualifying IP rights need to sit, and structuring that ownership with the right agreements and licenses and paperwork that commercially makes the most effective use of patent box. I'm going to talk through how, without being an owner of qualifying IP rights, it's still possible to benefit from patent box through an exclusive license in relation to another company's IP qualifying rights, qualifying IP rights. I'm going to touch on the pitfalls to be avoided, particularly in relation to the drafting and the terms that need to be used and avoided within exclusive license arrangements. And then finally, sharing some insights where the patent box regime, which Marketa's touched on already, where the patent box regime provides specific provisions which aim to widen the scope of how individuals and businesses can potentially benefit from patent box. So as Catherine has helpfully set out, patents are filed in the name of individuals. And an initial but very important piece of legal housekeeping is to clarify who actually owns the patent. Is the patent still owned by the individual? Is the patent assigned to an organization such as a university or a company? And typically this would be covered with the contract of employment that would be between the individual and the organization or the company, or it might be a separate assignment of intellectual property rights. And our role here would be to look at the drafting and the wording in relation to those documents so we can understand actually where is the legal ownership of the IP sitting. And in the absence of those documents, we can then make sure that we can put the right documents in place so that the IP sits where it needs to sit in relation to getting the benefit of patent box. And as Catherine has touched on, for the purposes of patent box, we're only interested in a company that legally holds the qualifying IP rights or an exclusive license in respect of the qualifying IP rights. Now, I touch on the exclusive license next, but as a company that is looking to hold a qualifying IP right, as Marketa touched on in the beginning of her presentation, you need to be able to demonstrate that you satisfy the development condition. Now, in short, acquiring rights to and marketing a fully developed patent or invention or a product incorporating the invention is not going to be sufficient. And this is where we come in and we can help companies, we can help people understand, well, what are specifically the legal hurdles that need to be satisfied so that you can demonstrate that you've got the relevant things in place to demonstrate that you've met the development condition. And finally, with all the right qualifying conditions being met, it would then be important to talk through what the business plans are for commercializing the value in the patent. So typically the questions here would be what investment is going to be needed? Is that money coming from an external third party? And how do these arrangements need to be structured and set out? And a key part that I touched on, the business plan, I mean, that's key. I mean, the business plan would be typically appended to a license agreement. And there would be provisions in the license agreement which would tie to metrics and performances within the business plan. In terms of the commercial arrangements that need to be mapped out, one of the options available, as I've touched on, is the exclusive license. Now, the purpose of an exclusive license is to create the opportunity to benefit from patent box where you do not own the qualifying IP rights. So hopefully that's clear. You don't have the qualifying IP rights, but you can become a qualifying company and benefit from Patent Box through an exclusive license in respect of qualifying IP rights owned by another company. Now, an exclusive license needs to satisfy key legal requirements and contain relevant triggers that satisfy HMRC for the purposes of Patent Box. And there are key ones. The first, the principal right, is that the license must be granted by the person who holds either the principal right or an exclusive license in respect of the principal right. So hopefully that's clear, that if you're actually a holder of an exclusive license, you can yourself then grant an exclusive license to a third party. The license must also provide one or more rights to the exclusion of all other persons in one or more countries or territories. And importantly, it's often not necessarily understood at the outset. This includes excluding the owner of the IP, the qualifying IP rights, excluding the owner of the patent. And it's worth noting that while the patent owner is excluded, they may benefit from royalties, and that would typically be set out in the terms of the license agreement. The other important point is that an exclusive license is different, for example, from a sole license. Now, a sole license would be where the patent holder is allowed to exploit the patent in competition with the licensee. So this comes down to the drafting of the document. So it's really very much from HMRC's perspective, it would be reviewed on the merits of the drafting. So we just need to be clear that the drafting demonstrates that it is an exclusive license and not a sole license. And this is where the advice is key. Another aspect of the license is that it must provide the right for the licensee to bring proceedings without the consent of the owner of the patent, without the consent of the proprietor, or any other person for that matter, for any infringement of the license rights, or that the licensee has the right to receive the whole or a greater part of any damages awarded by any infringement. So these are the litigation rights referred to here on the slide. So typically, as a minimum, an exclusive license is likely to limit the use of the patent to a particular territory or field of use. It's worth pointing out it won't necessarily do that. You could have a global license, but it would, more often than not, there would be limitations around territories and fields of use. It's likely to contain a minimum term tied to the duration of the patent, or a minimum period that provides a level of protection, so you have a level of protection in relation to the investment that's being committed in relation to the development. It's likely to be time limited, and it would explain, as I touched on, it would explain how the royalties are to be determined, and it would set out the responsibilities for enforcing patent rights in the event of infringement. Another key part here is that the exclusive license needs to ensure that it doesn't fall foul of the anti-avoidance rules. And you may recall Marketa touched on the anti-avoidance rules at the beginning in her presentation. So we need to be alert to the anti-avoidance rules. These are statutory rules that prevent companies from seeking a tax advantage by artificially inflating the patent box tax deduction. So there are statutory rules in place that prevent, for example, granting non-commercial exclusive licenses, conferring exclusivity rights simply for the purposes of gaining the benefit of patent box. Equally, there might be there are rules that prevent the renegotiation of existing non-exclusive license to make it exclusive, again simply for the purposes of gaining the benefit of patent box. I thought it'd be helpful just to talk through a quick example, and I've made these names up, but you have, for example, Supercoms Limited grants an exclusive worldwide license to Lightning EV PLC to install its patented communications device into Lightning branded vehicles. Now, under the terms of the license, it says that there are no other licensee will be permitted to install the players into Lightning's vehicles. So this would be commercially irrelevant, as only Lightning EV PLC has the right to decide what extras should be installed in their own vehicles. And no other company outside Lightning EV PLC group could be granted a right by Supercoms to install a Supercom patented communication device into Lightning branded vehicles. So this example is an example where the exclusive worldwide license would be ignored for the purposes of patent box. Now, there are other additional rules that prevent, for example, incorporating a qualifying item into another non-qualifying item, and both Marketa and Catherine have touched on this. So, for example, you have a device that you have a patent on, and you include it in another device, but when you include it in that device, it actually has no role, no function, and no use. The only reason that you'd be including it would be to gain the benefit of patent box. Then there are rules that would prevent you from doing that. There are also additional rules that prevent tax advantage schemes, where companies try and put in clever tax advantage schemes which they would not be able to benefit from in terms of patent box. The key really here is that in relation to, if you have a tax investigation further down the line, then it's important to ensure that you've got the relevant advice up front and early, so that you can ensure that the drafting, for example, in relation to the exclusive license, you have a valid license which is HMRC compliant. Now, as mentioned at the start of the presentation, the patent box regime contains provisions which aim to widen its scope of use. And we've explained the patent box is only open to qualifying companies. However, the regime contains specific provisions which allow companies in partnership, cost-sharing arrangements, and groups of companies. So here we have the opportunity where a qualifying IP right may be developed using any one of these provisions, but it is important to understand that actually they come with their complicated rules and conditions that apply in how these arrangements can be set up and qualify for patent box. Companies in partnership, for example, this is where it allows trade profits to be computed as if the partnership were a company, and each partner to be allocated an amount of those profits based on its profit share. And then in cost-sharing arrangements, so in cost-sharing arrangements, for example, you might have the know-how, you might have the IP, but no money, or you might have money, you might be an investment vehicle, but you don't have the know-how or the IP. And cost-sharing arrangements allows businesses to establish separate legal entities or simply contractual arrangements to share the costs and risks of developing, producing, or obtaining assets, services, or rights. The important thing here is that in these arrangements, clearly legal advice and structuring and negotiating these arrangements to satisfy patent box is really key, and it's important to get that advice early on. So thank you. That brings my part of the presentation to a close, and I'll now hand over to Matt.
Thanks, Justin. And I can certainly say that from a patent attorney's point of view, we're always glad to have the advice of Justin and his colleagues to guide us through those commercial sides of things. The slide that's up on the screen now, we got together yesterday and said what are the key take-home messages that we would like for people, and as you can see there along the top line, the theme is definitely plan early. Plan early, speak to us early. Might not necessarily do things straight away, but at least if you've approached us and the team, then we can get the right people ready to help. And make sure it's always easier to sort things out earlier in the process, in my experience. So certainly plan early would be in bold. That's probably the most important thing here. So yeah, I'd like to say a really big thank you to all three of the presenters. Excellent presentations. A quick question came in whether we're going to make the presentation available as a PDF. I think we'll be able to do that, no problem, after, so we can distribute that. And also the recording, we'll be able to make that available to everybody as well. There's a couple of questions that came in from somebody that couldn't attend, but Justin, I've got one for you. Could you just explain simply the difference between a non-exclusive, exclusive, and a sole license, and is it easy to make sure that's very clear in an agreement?
Morning, Matt. So yes, it's yes, it's easy to make it clear. I think the notion, just I touched on it in my presentation. I mean, the notion between sole and exclusive, I think is really, we've often seen this in the context of where it's typically when it was with the notion of drafting from the US, there seems to be confusion as to their understanding of a sole and an exclusive license. So as I touched on, a sole exclusive license means that it's exclusive to that party, and in the context of patent boxes, it also excludes the rights of the actual patent owner. And whereas a sole license would actually permit, as I touched on in my presentation, would permit the patent owner to compete directly with the licensee. So for the purposes of patent box, that sole license, if that's how it's drafted, then that would not fall within the validity of it being an exclusive license for the purposes of patent box.
Thank you. Another one that came in earlier, I'm just going to read it out. This might be Catherine and or Marketa. Is it true that it can take a long time to get a patent application awarded? And can you backdate patent box claims during the period that your patent application is not granted?
I'll take the first part of that question, Matt, regarding how long it takes to get patent granted. Yes, it can take a while, certainly compared to other processes. If we are hurrying the procedure along, we could be looking at a year. Under normal sort of other timescales, we could be looking at anywhere between 3 and maybe just over 5 years, actually.
Yes,
to answer the second part of the question.
Yes, you
can.
I
mentioned that. The mechanics
is that when you granted a
patent.
I have
an echo.
Is that
on?
Does everyone? Okay. Yeah, so once the patent is granted, you can go back and make a retrospective claim up to 6 years throughout the period your patent application was pending. And how it works, you are not amending your previous tax computations. It's basically an enhanced claim put in the tax computation in the year when that patent is granted.
Excellent, thank you both. Another one that came in was, is it possible to have R&D tax relief and also patent box at the same time? In other words, are they mutually exclusive, or can you run them alongside each other?
Yeah, absolutely. So they're not mutually exclusive. It's completely common for companies to have R&D program, which is doing new R&D projects, while some of those projects already finished and resulted in qualifying IP rights. So yes, we can make patent box claims alongside of R&D claims. Absolutely.
Perfect. That last one from me. IP holding companies is a subject that often comes up from clients, and I pass it very quickly on to Justin and his team. So perhaps we could just have a bit of comment about whether IP holding companies are possible and whether they can work within the patent box regime, especially when we're talking about the requirements for making a successful patent box claim.
And Marketa might want to jump in here too from a tax perspective. So I mean, it's in short, it's possible, but I mean, it's important that there is clear understanding that you can't simply just have a holding company that holds IP just for the purposes of getting the benefits of patent box, and there needs to be a demonstration that you're meeting certain conditions and hurdles that demonstrate that it's in relation to the activity that you're meeting the hurdles that would then allow you to have that holding company and the relevant subsidiary within the boundaries of the patent box regime. And that also links in with what from a financial and accounting perspective. I think that's right, Marketa.
So I think I touched on that earlier, and it's relatively simple to satisfy the conditions to be a qualifying company for patent box relief, but that scenario will cause lots of complications because of the R&D fraction in the computation. So I'd say that probably generally the IP holding companies, since the introduction of the new rules, so if you're subject to new patent box rules, then the IP holding company in most scenarios might not be a good idea, because it's unlikely that the IP holding company would also have the R&D cost in it. Although there are some options, so you can, for example, transfer a trait from one company to other company, and if you transfer a trait together with your IP asset, you're also transferring the R&D spend for the patent box purposes. But I'd say that these structures worked under the old patent box rules, but are less likely to work under the new patent box rules. And just a comment on the new patent box rules. So although the old patent box rules came in 2016, there were grandfathering provisions put in place. So the new rules applied to all new entrants from 2016, but whoever was already in patent box regime was allowed to use the old rules until 2021. So it's relatively recently when the old rules just disappear completely, and now everyone has to use the new rules.
Perfect. Thank you. Well, I think that's absolutely perfect timing. So thank you to everybody for attending today. And thank you also very much to our three speakers. As I say, we'll make everything available to you offline. If you want to get in contact with any of us, then please feel free. But thank you again, and enjoy the rest of your day. Bye-bye.
Thank you very much.
Bye.